I need to tell you something before I tell you this story. I am not a person who cries easily. I never have been. My father raised me to believe that composure was a form of respect, that when someone brings you their worst day, the least you can do is hold yourself together long enough to hear it properly. He was a quiet man, my father, the kind who expressed love through presence rather than words. And he believed that falling apart in front of people was a way of making their difficulty about you. You stay steady. He used to say, you stay steady so they don't have to. My mother used to say that I came out of the womb with my jaw set. My law school professor told me in my second year that I had the best poker face he had ever seen on a student, and that I should either become a judge or a card player. I chose the bench. I think he would have preferred the other option. He was, by his own admission, a man who enjoyed a good hand of cards more than he probably should have. In 40 years on the bench, I have heard things that would take the floor out from under most people. I have heard confessions delivered in a flat, factual voice that made them more disturbing, not less. I have heard grief so raw, it filled the room like smoke, and you could feel it pressing against the walls. I have heard parents describe losing children, and children describe losing parents. I have listened to testimony about things human beings do to each other that I would give a great deal to be able to forget, and that I have not forgotten, and that I carry the way you carry things when there is no other option. I have been threatened, insulted, manipulated, lied to directly to my face by people who looked me in the eye while they did it. I have watched defendants crumble and witnesses break and attorneys lose their composure in ways that ended careers. I did not cry. Not once, not in 40 years, until the morning of April 3rd. I want to be precise about what happened because precision matters to me and because this story deserves it. I did not tear up. I did not feel my eyes get wet and managed to blink it away before anyone noticed. I sat on that bench in front of a full courtroom with my clerk at her desk and the court officer by the door and a gallery that was perhaps half full with people waiting for their own cases to be called. And I wept openly for almost a full minute without being able to stop it, and without, after the first few seconds, trying very hard to. The case that caused it was filed as a small claims dispute. The plaintiff was a woman named Evelyn Marsh. She was 73 years old. She was suing for $420. That number will mean something to you by the end. I promise you that. I had seen Evelyn Marsh's name on my docket that morning and had not thought much of it. Small claims, $420, dispute with a neighbor over a fence repair. My clerk had summarized it in 2 sentences, and I had moved on to the next file. When she walked into my courtroom, I looked up. She was small, the kind of small that age makes some people, not frail exactly, but as though the years have slowly, gently reduced everything down to its most essential. She had white hair pinned back with 2 silver clips. She wore a blue cardigan over a floral blouse, and she moved carefully with the deliberateness of someone whose hips have been giving her trouble for a while, but who has decided not to mention it to anyone. She carried a small purse and a single piece of paper folded in thirds. She sat down at the plaintiff's table and placed the paper in front of her, smoothed it once with both hands, and looked up at me with brown eyes that were tired and clear and entirely without complaint. The defendant was her neighbor, a man named Robert Tillis, 54 years old, who had shown up with a contractor's estimate and an expression that told me he had already decided this was a waste of his morning. He sat back in his chair and looked at his phone. I called the case and asked Evelyn to explain what had brought her here. She unfolded her piece of paper. She had written everything down in careful, looping handwriting, the kind of handwriting you learn in school before keyboards exist, the kind that takes time and care. She adjusted her glasses and began. In October of last year, she said a section of the fence between her property and Mr. Tillis's property had come down during a storm. 3 panels. She had contacted Mr. Tillai to discuss splitting the cost of the repair, as the fence sat on the property line and had always been maintained jointly. Going back to the previous owners on both sides, Mr. Tillis had agreed. He had suggested a contractor he knew. The contractor came, assessed the damage, and gave an estimate of $840 for the 3 panels. Evelyn had paid her half, $420. She had written the check the same week because that was how she did things, but promptly, without waiting to be reminded. Mr. Tillis had not paid his half. She had waited 2 months. She had knocked on his door twice. She had left a note. She had called once and left a voicemail. He had told her on the one occasion she reached him directly that he was going to take care of it. He had not taken care of it. The contractor, who had completed the repair in good faith, had since sent Evelyn the second invoice. She had paid it another $420 because she did not know what else to do, she said, and she did not want the contractor to suffer for someone else's failure to keep his word. She had paid $840 for a fence repair that was supposed to cost her $420. She was here to recover the difference. That was the case. Straightforward, documented. The contractor's invoice was on the paper she had brought. Her 2 canceled checks were there too, photocopied side by side in the careful, organized way of a woman who has been keeping her own records for a very long time. I looked at Robert Tillis. He shrugged and said the timing had been bad. He'd had some expenses he was planning to pay her back. I asked when he said he wasn't sure exactly. I looked at Evelyn. She was watching him with an expression I recognized. Not anger, not bitterness, just a very quiet, very tired recognition of a thing she had already known and had come here hoping to be wrong about. I was about to rule. It was an open and shut case. The documentation was clear. The agreement was clear. And Robert Tillis had no defense beyond inconvenience. I was going to fine for the plaintiff, award $420 plus filing costs, and move to the next case. And then I asked the question I almost didn't ask. I don't know exactly why I asked it. 40 years of instinct, maybe something in the way she had smoothed that piece of paper. Something in the 2 canceled checks photocopied so carefully as though $420 was something she had needed to account for very precisely. I said, Mrs. Marsh, I want to ask you something, and you don't have to answer if you'd prefer not to. The second payment, the one you made to cover Mr. Tillis's share, was that a difficult decision for you financially? She looked at me for a moment. Then she said, Yes, Your Honor, it was. I said, Can you tell me a little more about that? She looked down at her paper. She was quiet for long enough that I thought she might decline. Then she folded her hands in her lap, and she looked back up at me, and she began to talk. Her husband, Harold, had died 14 months ago. Pancreatic cancer, from diagnosis to the end, was 11 weeks. She said it that way, 11 weeks. The way you say a number when you have counted it so many times, it is worn smooth. They had been married for 51 years. He had been a high school history teacher for 34 of those years. American history mostly, with a particular devotion to the Civil War period that his students either found infectious or mildly exhausting, she said. And another small smile came and went. He had coached the junior varsity baseball team on the side for 20 years because he loved the game and because he believed, she said, that boys needed someone to show them how to lose gracefully before they could learn how to win at anything that mattered. He had been, by everything she described and everything I could hear in the way she described it, a good man. The particular kind of good that is not loud about itself, that shows up consistently over decades in small, reliable ways that you only fully understand the size of after it is gone. After Harold died, she discovered something about their finances that she had not fully understood while he was alive. Not because he had hidden it from her. Harold was not that kind of man, but because she had trusted him to manage it. And he had managed it carefully and quietly and without worrying her the way he did most things. What she found was that the careful, quiet management had been covering a gap for several years, medical costs mostly. A cardiac event 4 years ago had required a procedure and a recovery and medications that their supplemental insurance had not fully covered. It had been significant. Harold had handled it. He had moved things around, she said. And then she paused for a moment as though she was still working out how to feel about that. And then she continued. She was not angry. She wanted to be clear about that. She said it twice, actually, in the careful way that told me she had thought about it enough to be sure. Harold had done what Harold did, absorbed the difficulty himself, and presented her with the smoothed-over version. It was one of the things she had loved most about him, and one of the things that had made his absence so complete, because the smoothing over was gone now. The difficulties were hers to see plainly, and she was seeing them. She had a fixed income, Social Security, and a portion of Harold's teacher's pension, which she received as his surviving spouse. She had the house, which was paid off. She had a savings account that was smaller than she had understood it to be, but it was there. She was not in crisis. She said it firmly with the tone of someone who does not want to be treated as fragile. She was not in danger. She had what she needed. But $420, she said, looking down at her paper for just a moment and then back up at me, was not a small number for her. It was a month of utility bills. It was the medication copays she had been deferring since January, waiting for her February Social Security payment to clear before she called in the refills. It was the winter coat she had decided to skip this year because the old one still kept the cold out well enough if she wore a sweater underneath. And there were things that seemed more necessary than a coat. She had paid it anyway both times because the contractor had done his job correctly and on time and deserved to be paid, and because she did not believe that other people should have to carry costs that were not theirs to carry. She stopped talking. The courtroom was absolutely silent. I looked down at my bench. I looked at the 2 canceled checks on that photocopied page. $420. $420 written in the same careful handwriting as her notes, signed with the same looping signature. And something broke open in me that I did not know was there. I have thought about this many times since April 3rd, turning it over carefully, trying to understand precisely what it was. I am a person who believes in understanding things precisely. It was not pity. Evelyn Marsh did not want pity and would have found it quietly insulting, and I would not have offered it to her. It was not sadness alone, though there was sadness threaded all the way through it. It was not even grief exactly, though it touched something in me that had to do with loss and with time and with the people we rely on to manage the